Well, we are finally doing this, Michelle. Thanks for your patience. I know that we had some issues going on, and this is a learning process for me too. Every show gets a little better, which means that this show will be the best show that I've done.
And such an exciting topic too. So
It is the most exciting topic. You know, the thing about it, Michelle, is these are things that people don't want to think about, but are so important to know about. And I think one of the main things is that if you know about it, you might be able to avoid some of these issues in the future. Am I right?
absolutely. I mean, echoing what your last guest, Eileen Maastricht, and I hope I'm not butchering her name,
No, you
said.
said it right. I practiced multiple times.
Okay. Um, echoing what she said, properly worded documents in a lot of cases can avoid ever having to meet me.
Well, can you tell everybody a little bit about your background? I mean, you and I have similar backgrounds. We're both lawyers' kids, for better or for worse.
As much as my dad tried to talk me out of becoming a lawyer, I said, well, I'm going to go for it anyway. But he said it's the most hated profession, but here I am.
Yes. And what is it about your job that you like the most?
Well, I would have to say that every day is a brand new learning experience. There's never really even close to being the same issue twice. It's usually completely different, which means I'm continuously on a learning curve, but that makes it interesting.
Yeah, that's the truth. Well, tell us how you got into guardianship law.
Well, I was actually a journalism major in college because I like writing, and I think like you were in the journalism school at one time.
Yeah, communications, broadcasting.
And
So, reliving it here.
yes, we need to revisit that. So
Yes.
I liked writing, but I didn't want to starve to death as a journalist either. So I decided to get a joint degree in law and mass communications, and the UF Journalism School happily accepted me to their master program, and UF Law said, not so much. So off to Nova I went and joined you there. But as far as my first, I think your question was my first job out of law school. I joined a very small 2-person law firm. We did a lot of BI, plaintiff and defense. I did a lot of insurance defense. And I did that for about 8 or 9 years litigating. And then I had another kid, so I was out.
Mm-hmm. Well, that happens.
Sometimes, twice.
Well, you have 2 wonderful daughters.
Mm-hmm.
So, well, let me ask you this. Going into guardianship. Now, when we talk about guardianship, a lot of times what comes up is competency. And you and I had a conversation about that, the word competency, because we throw that word around. Oh, he's incompetent. He doesn't know what he's doing. In the legal sense, what is competency?
So actually in my world, in the world of guardianship, it's really capacity. It's whether someone has the ability to take care of their financial affairs or their physical being. And if they can't, or if a family member or someone believes that they lack capacity, then what they can do is petition the court to have them declared incapacitated. And then once that is complete, which is one process, a second process will begin to appoint a guardian to remove some, if not all, of that person's rights to handle their own affairs, whether it be over their physical person or over their property, or both, in which case it's called a plenary guardianship.
How can somebody avoid all of this in the future? I mean, it sounds like if you get to that point, it's going to be a little bit pricey.
It's an expensive, it's not only expensive to open a guardianship and go through that process, it's expensive to maintain a guardianship. When you're talking about a minor guardianship, a child, you're maintaining that guardianship until the kid reaches the age of majority, until they're 18. And in the area of adult guardianships, you can pretty much assume that that guardianship is going to remain in place until that person's rights are restored, which are rare, or until they pass, because they're going to need this guardianship for their life. So there's an exorbitant cost in setting it up and maintaining it over a long period of time. Was that the question?
What are some of the legal things that you can do now for a person that avoids the necessity of a guardianship or an incapacity motion, anything like that?
Right. So that was your original question, wasn't it? And as your last guest said,
it's just like news TV. You answer what you want to answer, but at the same time, all of it's valuable here, whereas on news TV, usually not so much.
Well, let's not discredit the media. But
yeah. I'm not even going to touch it.
As your last guest mentioned, a properly worded durable power of attorney goes a long way in avoiding a guardianship. I'll give you an example. Husbands and wives assume that because they're married, they have the authority to take on each other's, let's say, guardianship type roles in the event that they became incapacitated. People assume that they can take care of their husband or wife's affairs. That's not true. That's not the assumption under the law. And for example, I do have a husband and wife guardianship. A gentleman suffered a traumatic brain injury, and they did not have any least restrictive means available to them. They did not have a durable power of attorney in effect, and therefore the only alternative in that case was a guardianship, which is a court-involved process.
When you get the court involved, that's generally not a good thing. Am I right?
Correct. It's very invasive into people's lives, and in my experience, they really come to resent it, whether it's for a minor or a spouse or another relative. You have to petition the court every single time money needs to come out of a restricted depository account. That's how the court protects the ward's assets, is through a restricted bank account. And so as a spouse or a parent, to have to go to the court every time you need to use these funds for the benefit of the ward, you're petitioning the court and essentially airing all of your private issues to the court. And they are private proceedings, but it's still, in my experience, very invasive to the families involved.
So if you could let everybody know what the cost would be for certain things like durable power of attorney and other documents that you could get in advance of potential incapacity, as opposed to not having those documents and having to go for a full-fledged guardianship or incapacity hearing. A ballpark.
So, as lawyers love to say, it depends. However,
I had a professor that used to say that.
Only every lawyer I've ever met has ever said that. But basically, you're talking about, in a vacuum, if you just require that type document, you can assume ballpark around $500, $750 for that document alone. It depends on the attorney. It depends on how deep you're going. I have powers of attorney that add language to govern taking care of pets and things like that. There are digital aspects to a power of attorney. You want a very strongly worded power of attorney. It does give the other person, your agent, a lot of power, But what that does in effect is it avoids this, invasive guardianship process. But unfortunately, a lot of times a guardianship is going to be unavoidable.
Mm-hmm. Well, one of the areas that you and I have spoken about multiple times is when you have a personal injury case involving a minor, meaning somebody who's under 18 years old. When somebody's a minor and we have a settlement of over $15,000, that's a situation where you've seen that quite often. Am I right?
Yes, I've had several minor guardianships.
Tell us a little bit about that and why those are necessary if you get a settlement over $15,000.
So, in their infinite wisdom, the legislature has decided that parents are the natural guardians of their children's person and property, up to and exceeding and including $15,000 worth of assets. Sometimes, and it could be for an inheritance also, not just a minor's settlement, but as you were stating, in the terms of a minor settlement, if a minor is going to receive more than $15,000, then the legislature has decided that a court should oversee control of those assets, because let's be honest, not every parent has the best interest of their child at heart, and we don't want that money to be wasted. The flip side of that is since it's costly to open and maintain, a lot of those assets are being spent on attorney fees and court costs, and the reality that every time you need to utilize those funds, you're going to have to petition the court to do so. So that involves attorney time and court costs. But sometimes a minor can be receiving, well in excess of $15,000. But there are ways, depending, to avoid the need of a minor guardianship. In some cases, in my experience, I've been successful in in getting a court to put the money into an annuity, let's say, that keeps the money out of the hands of the minor. Florida prepaid college plans, but usually courts are more inclined to do that when the parents of the child usually have other financial means to take care of the kid. Otherwise, it really should be, I don't want to say at their disposal, but available for them to use for their needs.
It's kind of funny that it's $15,000. I think it's been $15,000 for what, 40 years?
I don't know, but as long as I've been doing this.
Just sort of like with circuit court, if it's over $15,000, you're in circuit court. Under $15,000, you're in county court. It just seems like it's a very arbitrary number to begin with. It seems like it should kind of change with the rates of inflation and cost of living that has increased over the past 30 years, but it hasn't.
It hasn't, and I have so many times been asked to open a guardianship, and these kids are literally on the threshold of that number. To avoid a guardianship, we almost have to, as attorneys, reduce what they're going to get just to avoid it because you're so close. And that's unfortunate.
I've actually had situations, Michelle, and I'm sure you've seen this, where the child is going to be 18 in 6 months, and we kind of postpone the settlement until the child becomes of the age of majority to avoid having to go through this guardianship, which, if I'm not mistaken, probably would cost somewhere between $3,000 to $5,000 otherwise.
That's pretty accurate, and it's a waste in a lot of cases. And I've had to really try to be creative and trying to avoid it in the past. Once I was successful, but in other times the court insists there's going to be a guardianship here.
Yeah, and there's really no way to do it, and even no way to avoid it. I mean, even if your case is out of lawsuit, you still have to file these papers in order to do it. If you have a young minor, correct?
Correct. And the process for adults, and there are cases where an injury will will create incapacity in an adult, and there's settlements there, and the procedure for setting up an adult guardianship is completely different, because then you're dealing with a medical panel, a panel of three medical professionals in different areas to evaluate this person, to file reports. All of these people need to be paid, including an attorney ad litem who's appointed to represent the interests of the ward in this case. That person needs to be paid if the ward has assets.
When you say ward, can you tell everybody what you mean by that?
The ward is who will ultimately be the person who has been declared incapacitated. So, there's in the area of an adult guardianship, that's really a two-step process. The first is having this person declared incapacitated. Usually it's a magistrate judge who is making that ultimate determination based on the reports of the medical people involved, and the attorney ad litem. And then it's a matter of how many, if not all, rights are removed. And then the second step is appointing a guardian. And that person ultimately will be, oh, now I can hear a little echo. But
that was my iPad.
okay. Then after, a guardian is appointed, that person's responsible for doing certain annual reports every year over their assets and over their person, if it's a guardianship over their person and property. And then a lot of times you're dealing with people who don't agree on who the guardian should be. And then you have litigation. Fun.
Good times.
Good times. Yeah.
I think that when people talk about incapacity, though, and when they talk about incapacity or somebody's incompetent or anything like that, which is something that I brought up in the beginning, can you express how hard it is to declare somebody incompetent?
Well, usually I want to say in my experience, it's been pretty obvious. For example, you can do this on an emergency basis. And I've recently did an emergency guardianship where a very elderly person was no longer even coherent, and that becomes a very quick and easy process. But I do have other cases where it's not so cut and dry, and then it becomes a matter of what rights are going to be removed. Is it their right to just contract, marry, determine their living arrangements? What if this person, has only a mental disability and doesn't believe that they themselves are incapacitated? It takes 3 medical professionals from different areas of medicine, including 1 doctor. The others can be a LC, a licensed clinical social worker, like your wife. They could be other areas, and those 3 people have to come to the same conclusion. And there's usually an evidentiary hearing in front of a magistrate to make that ultimate determination. But in my experience, it's been relatively obvious that the person was incapacitated.
So if you, for example, have a family member that just makes bad decisions, you can't have the court declare them incompetent.
Not without more proof, no. And then this person sometimes has to be compelled to subject themselves to the examinations, which aren't going to be easy either. Sometimes you might, I will give you another example, and that's the best way I can do this, is I was contacted actually by legal aid, and it was a mother, and it was a very heart-wrenching story of a mother who has a mentally disabled child who's also a drug user. It's an adult child, but a child of hers nonetheless, and very upsetting. And the difficulty in that case was going to be finding this child of hers and having him evaluated. And it was going to be almost impossible to do. But had he been willing to subject himself, or had he been available to evaluate, it's likely that he could have been declared incapacitated and there could have been a guardianship over him that would have helped him out a lot.
Unfortunately, without his cooperation, it was going to be really difficult to do that.
In that case, yes.
Yeah. Well, obviously, we all know that you do guardianship, you do incapacity, deal with all these different issues. Can you tell everybody a little bit about some of your involvement in the community? I know that you're you have some very deep passions.
I'm pretty passionate about animals. Maybe it's along the same lines of the whole guardianship thing, helping creatures who can't help themselves. So yes, I'm very involved in animal rescue. It's like the mafia. You get sucked in and you're never getting out. And so as a result, I have 5 cats. But I also like to help other animals as well, and I don't discriminate against dogs either.
What organization are you involved in?
I am with Saving Sage Animal Rescue. It's a small no-kill shelter and rescue in Fort Lauderdale. Come volunteer with us. Come volunteer with us.
With all my time, maybe I will.
There's plenty of pit bulls for you.
Yes, you know I have a soft spot for rescue animals. Well, can you let everybody know if they have any questions, how they can reach you, Michelle?
Sure. I am in the process of revamping my website, but my phone number is 954-825-0398. You can email me at mreichler, that's MREICHLER, at reichlerlaw.com. And that's the best way to reach me.
Okay. Well, listen, I really appreciate you taking the time to speak with some of my friends, some of the firm page, and getting out there and really educating the public about an area of law that people really don't know enough about. And again, can you give your number out one more time?
Sure. And I would say that most of the people who call me really don't have any idea what guardianship involves. Even half of the attorneys I talk to really don't understand what exactly is involved. The best way to reach me is 954-825-0398. And I thank you for having me on the Jeff Show.
Well, I'm not calling it that, but
okay.
Jessica thinks I should call it that. But
Jess, I'm with you.
I'll stick with questions for lawyers. I have to stay humble.
Okay, keep it low.
You know. All right. Well, thank you, everybody. I'm Jeff Adelman. If you ever have any questions, my number is 954-341-2777. If you have any areas of law that you would like to see a specialist come on and talk about, call me anytime. Also, you can email me at jeff@adelmanlawyers.com. And of course, you can message me here on Facebook. Have a terrific Wednesday, everybody. Thanks for watching.
Thanks.